All right, we are live. Hello to my legal at some point peeps. I'm calling y'all law students and the jury right now, but we'll know when there's a for real like concrete when there's a for real concrete name. It's probably gonna be on some shirts and stuff. But right now, y'all are my law students and my jury right now because I feel like that's neutral and I'm not taking nobody else's stuff on accident. So yes, but hey, good morning. Let's get straight into it. Well, hi Bonnie. Hey Sharon. How are y'all? Good morning. So let's get into it. So first we're looking at the when they asked for the order to be unsealed so then we could see it publicly. So it says, upon the application of the United States by the United States Attorney for the Southern District of New York, Damian Williams, by Assistant United States Attorneys Meredith Foster, Emily A. Johnson, Christy Slavic, Madison Reddick Smizer, and Mitzi Steiner, it is found that the indictment in the above captioned case is currently sealed, and the United States Attorney's Office has applied to have that indictment unsealed, and it is therefore ordered that the indictment in the above captioned action be unsealed and remain unsealed pending further order of the court. So that's when we finally, well, us, in the public finally got to see what was going on. And then we're about to look at the actual indictment. Let's see here. All right. And then after the indictment, I do have a couple of other documents to, well, it's not a couple, it's a few other documents to look at related to Diddy as well and this case. So, hey, Baby Peaches. Hey, Angel One. Hi, Need W, Pisces Life. Hi, y'all. Good early morning to y'all. All right. So it says count one, racketeering conspiracy. The grand jury charges for decades, Sean Combs, I'm not supposed to read all his names, the defendant abused, threatened, and coerced women and others around him to fulfill his sexual desires, protect his reputation, and conceal his conduct. To do so, Combs relied on the employees, resources, and influence of the multifaceted business empire that he led and controlled, creating a criminal enterprise whose members and associates engaged in and attempted to engage in, among other crimes, sex trafficking, forced labor, kidnapping, arson, bribery, and obstruction of justice. Y'all know this list. I could not think of that other man's name, but y'all, Epstein. I finally remember it was Epstein. When Epstein's list came out and everybody was puckered up if their name was gonna come on that list. This is going to be another Epstein list because they're calling it a criminal enterprise, which means others shall be named. Hi, Bama girl. Hey, Kim Jones. Okay, so Sean Combs, the defendant, operated his business headquartered at various times in Manhattan and Los Angeles under a variety of United States-based corporate entities, including Bad Boy Entertainment, Combs Enterprises, and Combs Global, collectively the Combs Business. Corporate entities in the Combs Business included, among other things, record labels, a recording studio, an apparel line, an alcoholic spirits business, a marketing agency, and a television network and media company. At all times relevant to this indictment, Sean Combs, the defendant, engaged in a persistent and pervasive pattern of abuse toward women and other individuals. This abuse was at times verbal, emotional, physical, and sexual. As part of his pattern of abuse, Combs manipulated women to participate in highly orchestrated performances of sexual activity with male commercial sex workers. At times, Combs and others acting at his direction made arrangements for women and commercial sex workers to fly to Combs' location. Combs ensured participation from the women by, among other things, obtaining and distributing narcotics to them, controlling their careers, leveraging his financial support, and threatening to cut off the same, and using intimidation and violence. And I know it was reported that there was and we might get into it in one of the letters or something, but there was a pink powder that was found when his home was raided, and it was found on him again later somewhere else, and it was believed to be like basically some type of ecstasy substance or something like that. Hey, Miss Cutie Pie in the bushes. Physical abuse by Combs, the defendant, was recurrent and widely known. On numerous occasions from at least in or about 2009 and continuing for years, Combs assaulted women by, among other things, striking, punching, dragging, throwing objects at, and kicking them. These assaults were at times witnessed by others and included one instance at a Los Angeles hotel in or about March 2016, which was captured on video and later publicly reported, where Combs kicked, dragged, and threw a vase at a woman as she was attempting to leave. When a member of the hotel security staff intervened, Combs attempted to bribe the staff member to ensure silence. Combs's violence was also not limited to these women. It extended to his employees, witnesses to his abuse, and others. Combs used the Combs business, including certain employees, to carry out, facilitate, and cover up his abuse and commercial sex. Those employees, including security staff, household staff, personal assistants, and high-ranking supervisors and other close associates, acted as Combs's intermediaries, and their conduct was facilitated and assisted by Combs's control of the Combs business, which I'm not surprised because they always have a team that helps ensure they get to keep doing what they're doing, that get to keep doing what they do. And yes, I understand that there will be some of those that it is done by intimidation, others it'll be for other reasons, but overall they need a team. Just like R. Kelly had a team, they always need more than just themselves to do it, especially on a scales like this. Hey, April with the 2 L's. All right, so it says the Combs Enterprise, from at least in or about 2008 through on or about the date of the filing of this indictment, Combs and others known and unknown were members and associates of a criminal organization, the Combs Enterprise. Members and associates of the Combs Enterprise engaged in and attempted to engage in, among other activities, sex trafficking, forced labor, interstate transportation for purposes of prostitution, coercion, and enticement to engage in prostitution, narcotics offenses, kidnapping, arson, bribery, and obstruction of justice. Goodness. What was I going to say? Oh, it's so interesting that when the enterprise part is, that's like the YSL thing where they're trying to show us an enterprise gang, all this other stuff. And so it's just interesting to see the Combs Enterprise, like they are also defining it that way to show it was more than just him. And it, because racketeering is part of RICO, I'm pretty sure. The Combs Enterprise, including its leadership, its members, and its associates, constituted an enterprise as defined by Title 18, United States Code Section 1961-4, that is a group of individuals associated in fact, although not a legal entity. The Combs Enterprise consisted of Sean Combs, the defendant, entities within the Combs business, including but not limited to Bad Boy Entertainment, Combs Enterprises, and Combs Global, individuals employed by and associated with the Combs business, and others known and unknown. The Combs Enterprise constituted an ongoing organization whose members functioned as a continuing unit for a common purpose of achieving the objectives of the Combs Enterprise. The Combs Enterprise was engaged in and its activities affected interstate and foreign commerce. The Combs Enterprise operated in the Southern District of New York and elsewhere. At all times relevant to this indictment, Combs was the leader of the Combs Enterprise. Combs, the defendant, and others known and unknown participated in unlawful and other activities related to the conduct of the Combs Enterprise's affairs. These individuals included certain Combs business employees, such as members of Combs's security staff, household staff, personal assistants, and high-ranking supervisors, as well as other close associates. Purposes of the Combs Enterprise. The purposes of the Combs Enterprise included the following: operating a global business in the media, entertainment, and lifestyle industries, including among other things, record labels, a recording studio, an apparel line, an alcoholic spirits business, a marketing agency, and a television network and media company. Preserving, which is called, from what I know, Revolt Media. I believe that it's Revolt TV and all that stuff. Preserving, protecting, promoting, and enhancing the power, reputation, and brand of Combs. the defendant as a musician, entrepreneur, and figure in the entertainment industry, enriching members and associates of the enterprise, including its leader, Combs, and in particular, those who demonstrated loyalty. Sorry, a yawn tried to get me, who demonstrated loyalty to Combs and willingness to conceal his crimes. Preserving, protecting, promoting, and enhancing the power of the Combs enterprise, including the power of its leader, Combs, through violence, use of firearms, threats of violence, coercion, and verbal, emotional, physical, and sexual abuse. Fulfilling the personal desires of Combs, particularly those related to Combs' sexual gratification, including through the exploitation of women and the use of commercial sex workers. Enabling Combs and other members and associates of the Combs enterprise to engage in unlawful acts of violence, including sexual violence, sex trafficking, forced labor, interstate transportation for purposes of prostitution, coercion and enticement to engage in prostitution, narcotics distribution, and other crimes, and concealing the commission of such acts. I also, I'm wondering if only the ones that came forward as far as willing to say they were victims were women, because it seems that it seems well known that he has male victims of sexual acts as well, but they keep saying just women. So I'm wondering if that's where they have the best evidence, because it's definitely not just women. Securing absolute loyalty from members of the Combs enterprise, including through acts of violence and threats, and protecting the Combs enterprise and its members and associates, including Combs, from detection and prosecution by law enforcement authorities through acts of intimidation, manipulation, bribery, and threats of retaliation against individuals who witnessed the crimes committed by members and associates of the enterprise. Good morning, Leah's grandma. Means and methods of the enterprise. Among the means and methods by which Combs and other members and associates of the Combs enterprise conducted and participated in the conduct of the affairs of the Combs enterprise included the following. Combs and other members and associates of the Combs enterprise wielded the power and prestige of Combs's role at the Combs business to intimidate, threaten, and lure female victims into Combs's orbit, often under the pretense of a romantic relationship. Combs then used force, threats of force, and coercion to cause victims to engage in extended sex acts with male commercial sex workers that Combs referred to as, among other things, freak-offs. Freak-offs were elaborate and produced sex performances that Combs arranged, directed, masturbated during, and often electronically recorded. In arranging these freak-offs, Combs, with the assistance of members and associates of the Combs enterprise, transported and caused to be transported commercial sex workers across state lines and internationally. Freak-offs occurred regularly, sometimes lasted multiple days, and often involved multiple commercial sex workers. During freak-offs, Combs distributed a variety of controlled substances to victims, in part to keep the victims obedient and compliant. Sometimes, unbeknownst to the victims, Combs kept videos he filmed of victims engaging in sex acts with commercial sex workers. After freak-offs, Combs and the victims typically received IV fluids to recover from the physical exertion and drug use. Jesus. Members and associates of the Combs enterprise, including high-ranking supervisors, security staff, household staff, personal assistants, and other Combs business employees, facilitated the freak-offs by, among other things, booking hotel rooms for the freak-offs, stocking the hotel rooms in advance with the required freak-off supplies, including controlled substances, baby oil, lubricant, extra linens, and lighting, cleaning the hotel rooms after the freak-offs to try to mitigate room damage, arranging for travel for victims, commercial sex workers, and Combs to and from freak-offs, resupplying Combs with requested supplies, delivering large sums of cash to Combs to pay the commercial sex workers, and scheduling the delivery of IV fluids. In or about March 2024, during searches of Combs' residences in Miami, Florida, and Los Angeles, California, law enforcement seized various freak-off supplies, including narcotics and more than 1,000 bottles of baby oil and lubricant. Combs subjected victims to physical, emotional, and verbal abuse to cause the victims to engage in freak-offs. Combs maintained control over his victims through, among other things, physical violence, promises of career opportunities, granting and threatening to withhold financial support, and by other coercive means, including tracking their whereabouts, dictating the victim's appearance, monitoring their medical records, controlling their housing, and supplying them with controlled substances. During and separate from freak-offs, Combs, among other things, hit, kicked, threw objects at, and dragged victims at times by their hair. These assaults these assaults often resulted in injuries that took days or weeks to heal. Combs also threatened victims' careers and livelihoods, including if they resisted participating in freak-offs. Victims believed they could not refuse Combs's demands without risking their financial or job security or without repercussions in the form of physical or emotional abuse. Combs also used the sensitive, embarrassing, and incriminating records that he made during freak-offs as collateral to ensure the continued obedience and silence of the victims. Hey, Miss Cheryl Tuff from Seattle. Members and associates of the Combs enterprise, including Combs security personnel, at times carried firearms. On more than one occasion, Combs himself carried or brandished firearms to intimidate and threaten others, including victims of and witnesses to his abuse. In or about March 2024, during searches of Combs's residences in Miami, Florida, and Los Angeles, California, law enforcement seized firearms and ammunition, including 3 AR-15s with defaced serial numbers, as well as a drum magazine. Members and associates of the Combs enterprise enabled Combs's control over victims by following his directions regarding financial payments to victims, advancing or suppressing the victim's career opportunities, and acquiring the controlled substances Combs used to keep the victims compliant. Members and associates of the Combs enterprise at times witnessed Combs's violence toward the victims or the victims' injuries caused by Combs without intervening. Instead, members and associates of the Combs enterprise helped conceal the violence and abuse by, among other things, assisting Combs in monitoring and preventing victims from leaving locations such as hotels or Combs' residences. These occasions included instances in which a victim was required to remain in hiding, sometimes for several days at a time, to recover from injuries Combs inflicted without being publicly observed. Members and associates of the Combs enterprise also assisted Combs in locating and contacting victims who attempted to flee his abuse. When employees witnesses to his abuse or others threatened Combs' authority or reputation, Combs and members and associates of the enterprise engaged in acts of violence, threats of financial and reputational harm, and verbal abuse. These acts of violence included kidnapping and arson. In addition, on multiple occasions, Combs threw both objects and people, as well as hit, dragged, choked, and shoved others. Good morning, Mary Lindsay. When Combs' authority or reputation was threatened by the possibility of negative publicity or legal or law enforcement action against him, including in or about late 2023, following public allegations of Combs' crimes, Combs and members and associates of the enterprise pressured witnesses and victims, including through attempted bribery, to stay silent and not report what they experienced or knew to law enforcement. On phone calls, Combs and other members and associates of the enterprise, among other things, provided these victims and witnesses with a false narrative of events in an effort to conceal Combs' crimes. Combs caused these calls to be recorded on at least 2 occasions. The racketeering conspiracy. Yes, he was a monster. You said how she got away? I think she still just eventually left and was ready to endure the embarrassment and his threats and everything, because he would keep her locked up for days at a time. But overall, when I can't say details, but I'm just saying that I think the mental control was more than the emotional or more than the physical control of when he actually had her on lockdown. And I think she finally broke free of the mental control and finally was able to leave, darn the consequences and, what she reported after that. The racketeering conspiracy. From at least in or about 2008 through on or about the date of this filing of this indictment, Let's see. The defendant and others known and unknown being persons employed by and associated with the Combs enterprise described in paragraphs 6 through 12 of this indictment, an enterprise engaged in and the activities of which affected interstate and foreign commerce, knowingly combined, conspired, confederated, and agreed together and with each other to violate the racketeering laws of the United States, to wit, Title 18, United States Code Section 1962C, that is, to conduct and participate directly and indirectly in the conduct of the affairs of the Combs enterprise through a pattern of racketeering activity consisting of multiple acts involving kidnapping, chargeable under the following provisions of state law: multiple acts involving arson, multiple acts involving bribery, multiple acts indictable under Title 18 United States Code Section 1512 relating to tampering with a witness, victim, or an informant, multiple acts indictable under Title 18 relating to forced labor, multiple acts indictable under Title 18 relating to sex trafficking, multiple acts indictable under Title 18 relating to transportation and inducement to travel for purposes of prostitution and other illegal sexual activities, and multiple offenses involving the possession with intent to distribute or distribution of narcotics and controlled substances, including cocaine, oxycodone, alprazolam, we're going to say methamphetamine. There's a longer name than that. And dimethamphetamine is how I'm going to call that one, gamma hydroxybutyric acid, and ketamine, violation of distribution and possession with intent to distribute and conspiracy to do the same, aiding, abetting, and willfully causing. It was a part of the conspiracy that Combs, the defendant, agreed that a conspirator would commit at least 2 acts of racketeering activity in the conduct of the affairs of the Combs enterprise. Notice of special sentencing factor: from at least in or about 2009 up to and including in or about 2018 in the Southern District of New York and elsewhere, as part of his agreement to conduct and participate in the conduct of the affairs of the Combs enterprise through a pattern of racketeering activity, Combs agreed to, in and affecting interstate and foreign commerce, knowingly recruit, entice, harbor, transport, provide, obtain, advertise, maintain, patronize, and solicit by any means a person knowing and in reckless disregard of the fact that means of force, threats of force, fraud, and coercion, and any combination of such means would be used to cause the person to engage in a commercial sex act in violation of Title 18 United States Code Section 1591 A1 and B1. That was just count 1. This is count 2, sex trafficking by force, fraud, or coercion. Hey, Rhonda F., Reen Bass, Deborah Valentine. I know, Sharon. The grand jury further charges from at least in or about 2009 up to and including in or about 2018, the defendant in and affecting interstate and foreign commerce knowingly recruited, enticed, harbored, transported, provided, obtained, advertised, maintained, patronized, and solicited by any means a person knowing and in reckless disregard of the fact that means of force, threat of force, fraud, and coercion, and any combination of such means would be used to cause the person to engage in a commercial sex act and attempted, aided, and abetted, and willfully caused the same, to wit, Combs recruited, enticed, harbored, transported, and maintained a person, victim 1, and attempted, aided, and abetted, and willfully caused victim 1 to engage in commercial sex acts, knowing and in reckless disregard of the fact that victim 1 was engaging in commercial sex acts as a result of force, fraud, and coercion. Count 3, transportation to engage in prostitution. The grand jury further charges from at least 2009 up to and including in or about 2024, the defendant knowingly transported an individual in interstate and foreign commerce with intent that the individual engage in prostitution and attempted, aided, and abetted, and willfully caused the same, to wit, Combs transported, aided, and abetted, and willfully caused the transportation of female victims and commercial sex workers in interstate and foreign commerce on multiple occasions with the intent that they engage in prostitution. Forfeiture allegations. As a result of committing the offense alleged in count 1 of this indictment, the defendant shall forfeit to the United States any and all interest the defendant acquired or maintained in violation of Title 18 United States Code, Section 1962, and any and all interest in securities of, claims against, and property or contractual rights of any kind affording a source of influence over the enterprise named and described herein, which the defendant established, operated, controlled, conducted, and participated in the conduct of, and any and all property constituting and derived from proceeds obtained directly and indirectly said offense, including but not limited to a sum of money in U.S. currency representing the amount of proceeds traceable to the commission of said offense. So he has to surrender any identifiable asset that's connected to the Combs enterprise, which they already said that's bad boy. Now they've already many people have already broken ties. Companies have broken ties, like the Ciroc broke ties, Revolt TV broke ties. They might have bought him out, but that bought out money seems like it's gonna have to be surrendered. So yeah, that's it. Everything we know him for is named in here under the Combs enterprise. Good morning, LA girl. It is horrendous. I agree. Hi, Nanny of the Maroons. Yes, it has been going on for a long time. Yeah. True, because he did not do it alone, Nanny of the Maroons. Okay, it says, as a result of committing the offense alleged in count 2 of this indictment, the defendant shall forfeit to the U.S. everything they basically said in the first time. So, and then as a result of committing the offense alleged in count 3 of this indictment, he also has to surrender everything to the U.S. connected to the enterprise and everything else. Substitute assets provision. If any of the above described forfeitable property as a result of any act or omission of the defendant cannot be located upon the exercise of due diligence, has been transferred or sold to or deposited with a third person, has been placed beyond the jurisdiction of the court, has been substantially diminished in value, or has been commingled with other property which cannot be subdivided without difficulty, it is the intent of the United States, pursuant to Title 18, to seek forfeiture of any other property of the defendant up to the value of the above forfeitable property. So they get you one way or the other is what they're saying. So if he tried to do any of these above, they're still going to seek the penalty from him or the forfeiture from him equal to the value he transferred outside of their jurisdiction. Good morning, Mama Bees. Hey, Rhonda Moore. All the tea in China. Hey. Okay. So now we're going to, I do have other things. So we're going to look at let me see if we're going to open each exhibit, because the way StreamYard likes to share screens, it's annoying. So we'll see if it's worth it. Okay. So exhibit 1, they had the appraisal of his property. Okay. So yeah, I will show this. Hold on. Let me share my screen. One moment. Let's see. And shout out to Don Don for the exhibits. Okay, so it says, in accordance with your request, I have appraised the real property at 2 Star Island Drive, Miami Beach, Florida. The purpose of this appraisal is to develop an opinion of the defined value of the subject property as improved. The property rights appraised are the fee, simple interest in the site, and improvements. In my opinion, the defined value of the property as of June 28, 2022 is $48,500,000. The attached report contains the description, analysis, and supportive data for the conclusion's final opinion of value, descriptive photographs, assignment conditions, and appropriate certifications. Good morning, Janetta Speaks. Okay, so residential appraiser. We're not going to, y'all saw the property amount, but there's the breakdown in case you are like, you want to actually see it, but there's the breakdown. Let me look for my next exhibit while y'all can see that on the screen. Let's see. Okay, I'll just tell you their next exhibit says that there was a satisfaction of mortgage. This is for, which property is this? It's for a Florida property. It says that Satisfaction of note and termination of mortgage. The indebtedness under the note in the principal of $18,850,000 secured by the mortgage has been fully satisfied as of the date hereof, and the note and the mortgage shall hereafter be of no further force or effect. The lender hereby directs the clerk of the circuit court in and for Miami-Dade County, Florida, to cancel the mortgage of record. Let me see what Exhibit 3 is. All right, I'll bring this one up for y'all. Exhibit 3. All right, it says, Dear AUSAs, Johnson, Steiner, and Smizer. And that's assistant U.S. attorneys. Okay, as you know, we represent Mr. Sean Combs with respect to the ongoing investigation by your office into violations of Title 18 United States Code, and then they list the sections, and Title 21. We write to inform you that Tenny Garagos, partner at this law firm, has taken physical custody of Mr. Combs's passport and will retain the passport. Mr. Combs will not secure any other travel documents and will remain in the United States during the pendency of this investigation. In terms of domestic travel, we will advise you in advance of any travel within the continental United States. Thank you. Obviously, this was back in April 2024. So this was, he's in custody now, so it's not now, but back in April 2024, that's when they had said they had his passport. They notified the assistant U.S. attorneys they had his passport. Okay. Let's see. Hey, Sweet Essence. Hey, Arheb. Indigo Girl. Hey. Are they sure this man is only 54? The number of crimes that he is accused of seems more like he's closer to 90 years old. That's more than a lifetime. Right. Right. Hey, Purple Unicorn. Hey, Cece. Okay, so now we're going to let me look at the next exhibit here. Let's see. Oh. I wonder what this was. I'll show y'all. This is an email. I'll show it to y'all. So this is an email that came. So, March 13th, 2024. Okay, so it says, good afternoon, Assistant U.S. Attorneys Johnson, Steiner, and Smizer. My name is Mark Agnifilo, and I represent Sean Combs in connection with your investigation. I know we have never met, but I would like to speak with you and provide you with information that has come to my attention over the last couple of months. Thank you. I look forward to meeting you. So whatever that was about, March 13th, 2024. And then March 18th, 2024, it said, just following up on the email from last Wednesday, if you have a few minutes to touch base, I would really appreciate it. There's a situation that I would like to bring to your attention. So I wonder what that was for. I don't know. But what happened in March, then his passport was in custody in April. So obviously it has something to do with that. Let's see. Exhibit 5. Ooh, okay, yeah, I'll show this one. Some more emails. Hold on 1 second, y'all. Oh, shoot. Hold on. Okay. Let's see. So this is their next exhibit, and it says, let's see, where does it start? This is an email from June 9th, 2024. It says, Dear all, Mr. Combs will be departing from Miami at 6 p.m. tomorrow on his plane for Los Angeles. Tuesday, he and his family will depart on their road trip. They will go to Sedona, the Grand Canyon, Lake Powell, Zion, and Death Valley. We will be in touch with his flight information back to Miami. We hope you all had a nice weekend. That was June 9th, 2024. Then, so the U.S. attorney says, thank you for letting us know. They replied back that same day. Then June 10th is The same person that let them know about the travel says, "Good evening. Mr. Combs departed OPF at 10:24 p.m. and is expected to land at VNY at 12:17 a.m." Okay. And then the U.S. attorney said, "Receive, thank you." Okay. So they had to keep them abreast of his locations, obviously. Let's see. What's this one? Okay, this one I'll just tell y'all. It says, first they were saying Mr. Combs will be traveling to New York and Miami. And then they said he's no longer traveling to New York this week. And this was August 21st, 2024, when they said he's not traveling to New York anymore. So because it would take longer to bring it up, I was like, I'll just tell y'all that one. Let me see. Then, oh, okay. We'll look at this one together. So this one's a letter. So May 2nd, oh, you can't see it. May 2nd, 2024, it says investigation of Sean Combs, that's the subject, and it says, "Dear Assistant U.S. Attorneys Johnson, Steiner, Smizer, and Foster, as we discussed last week, Mr. Combs will be traveling from Miami to Los Angeles on May 27, 2024 to attend his daughter's high school graduation. He will be traveling to Los Angeles in his private airplane. On this point, we write to follow up on our phone call yesterday where we advised you that efforts have begun to sell this airplane, which is owned by a single member LLC called Love Air." And y'all know one of Diddy's names he gave himself was Love, Brother Love. "Because selling a plane takes some time, we will keep you updated as to the progress of this sale. As we advised you in early April 2024, this firm took possession of and continues to have possession of Mr. Combs' passport." Okay, so they wrote that on May 22nd, 2024. Let's see. SC said, "The lawyers are liars. I'm in Miami and he has been flying without a passport and out to sea. We see that big R shop because they pass us by. They passed us because location of docks. Where was he at when the plane rerouted at Homeland Security was raiding his home, failed to land?" Okay. And then this is the last exhibit. I'm seeing if it's worth it to bring it up. Okay, this letter, they were writing to inform the assistant U.S. attorneys that they also took possession of his kids' passports, including his daughter, his daughters, his mom. It says it's been sent to the Department of State for renewal. When they are renewed, we will take possession of those passports and let you know when we have them. We will update you as we receive more. Okay. So that was June 13th, 2024, when they took possession of several family members' passports as well. All right, now we're going to look at this document. This is the motion that his attorney had filed on September 17th, 2024 to try to get bond for him. All right. It says, "Dear Judge Tarnofsky, Mr. Sean Combs, through his counsel, submits this letter to the court for release on certain specified conditions. Yesterday evening, Mr. Combs was arrested on an indictment charging him with the following offenses. For the reasons set forth below, we ask this court to release Mr. Combs pursuant to our proposed bail package. This letter will walk the court through a series of actions taken by Mr. Combs over the past 6 months that prove that he is not a risk of flight or a danger to anyone in the community. These actions prove that Mr. Combs is eminently trustworthy, that he is demonstrably committed to showing his innocence in court in the context of this case, and that he should be released on the conditions proposed in order to do so." Before we read further, thank you, Judge, for denying this. I think twice. I heard twice it was denied. Thank you, Judge. I hope every time they hold their ground, do just keep denying it. Good morning, Kat. "The first thing the court should know is that when it became apparent to his counsel that Mr. Combs would at some point soon be formally charged, he did something extraordinary. He left his home in Miami and traveled to New York, the very location of the prosecutors and agents investigating him. Through counsel, Mr. Combs promptly told the government that he had voluntarily come to New York. offered to tell them specifically where he was, and offered to turn himself in at the appropriate time. Even though Mr. Combs came to New York, authorized his lawyers to tell the government of his location, and offered to self-surrender, the government effected an arrest last evening. This, we know, is the government's right. However, that he traveled to New York to self-surrender is also something the court should consider. No, we don't care. The court doesn't care. We don't care. Oh my God, I had read this paragraph and it made me think of something. This was around the same time, and the court's going to address it. They said this man was out here calling. Remember, okay, Don Richard from Danny Kane opened a lawsuit against him, right? Right before he was arrested, like maybe a day before he was arrested. And then the other person that was also part of Danny Kane and the Dirty Money group that they had, I believe she was part of Dirty Money as well. So not, dang, I can't even think of the girl name. Not the, oh gosh. Anyway, the other black girl, I can't remember her name right now. But she did come out and say, oh, I never witnessed this, but they come to find out he didn't contact this girl 58 times through like calls and some more through text messages. Tell them I didn't do this. Tell them blah, 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 harassing, tampering, all those things. Judge, do not let that man out, please. Bonnie said, yep, exactly. It was twice. They denied it. No bond for Diddy. And then Ernesto voice, right, Nanny of the Maroons. No bond. Oh, y'all, phone calls from prison. They're going to have his jail calls, I'm sure. I would think they would. So shout out to phone calls from prison right now. It is such an honor to be able to mod for them every now and again when I can jump in there. But shout out to phone calls from prison. They are doing their thing, and I'm so happy for them. Enemy of America threatening up to the hours of incarcerated. Kalina, thank you. Kalina, thank you. Okay. Let's see. 54 times he harassed her. Yes. Okay. So it says this was not the first action Mr. Combs took to show his trustworthiness and lack of flight risk. Indeed, it is part of a pattern since even before the March 25th, 2024 searches on Mr. Combs' residences. Mr. Combs and his counsel have been fully aware that the United States Attorney for the Southern District of New York has been conducting an investigation involving allegations concerning racketeering and sex trafficking and other offenses. Knowing for these many months that he would be indicted, Mr. Combs has done everything, as will be set out below, to work with the prosecutors in ways that are unusual, if not unprecedented. Right, she's scared. I agree, Sharon. I do think she's scared. We don't care, lawyer. We're going to read it, but we don't care. I just want you to know that. In light of these circumstances, he can rebut the presumption of detention here due to his extraordinary actions in this investigation. Mr. Combs should be released on the conditions proposed so that he can fight this case in court effectively. Oh, and Nanny of the Maroon said, I think I'm pretty sure he probably did call from other people's phones. She said, so he knew what he was doing. Of course he knew what he was doing. And again, that goes to the people that help him through possible coercion and things too, and intimidation, not just because they necessarily were trying to be bad people. That's when I have to let the justice system figure out how they're going to handle that, because I definitely understand. I do see him intimidating and threatening others, not just the victims that we know of in the light. Like they are themselves. Some of them are themselves victims. Some are just sycophants that was going to do it because it was Diddy and stuff like that too. But yeah, that's a complicated thing that I'm like, I will just read what the Justice Department decides to do with the people connected to the enterprise in certain ways. Because some, I think they wouldn't go after them and just want them to be witnesses. And some, they're going to have to go down because they also created victims themselves, So I'll just have to follow along, because that's when it starts getting real tangled up. The defense proposes the following bail package: a $50 million bond, co-signed by Sean Combs, his mother, his sister, the mother of his oldest daughter, and his 3 adult sons. Secured by the equity in Mr. Combs' residence located at 2 West Star Island in Miami, Florida, the appraised value of the home is about $48 million. The home is unencumbered. In anticipation of this bail hearing on August 20th, 2024, Mr. Combs paid off the remaining mortgage of about $18 million so that the home could be used to secure a bond and be free of a mortgage. Secured by the equity of Mr. Combs' mother's home located at Oh, sorry. They published this. I didn't publish this. But located in Miami, Florida. Mr. Combs' travel will be restricted to the Southern District of Florida and the Southern District of New York. No. Can I just be flying between New York and Florida after you? No, sir. To attend court, meet with his counsel, and attend medical appointments, which we will address to the court in a separate sealed submission, as well as the Eastern District of New York or the District of New Jersey, only to the extent that his travel to and from New York involves an airport in those districts. Mr. Combs' passport was surrendered to his counsel on April 1st, 2024. His counsel advised the prosecutors of this fact in an email dated the same day. Counsel will provide this passport to pretrial services. The passports of the following family members who have already surrendered their passports to counsel after the raids on Mr. Combs' homes: Janice Combs, Chance Combs, Jesse Combs, Delilah Combs, and Love Combs. I forgot he did name his youngest baby Love. He did do that, didn't he? Oh, Nate, you're in Europe? Shout out to you. I do have a PayPal. I will have to find it because I can't remember what the PayPal is under because it's not under trending at some point. So I will have to find it, but I thank you very, very much. I will figure it out. I appreciate you. SC said, nope, U.S. going to keep him, and unlike Epstein, ensure he survived to get the death penalty. The mother has the money, and the government want our money to pay victims. I don't know if this falls under death penalty. I know it falls under some of the charges are life, but I don't know if there's a death penalty sentence hanging on this one. They have lost their minds, not happening. Must have fell and bumped y'all heads. The nerve. Right, Bonnie. Right. Okay, it says, since at least April 2024, Mr. Combs has been making efforts to sell his airplane. We informed the government of these efforts in May 2024, as explained further below. Just this weekend, Mr. Combs entered into a letter of intent with a party to sell it. Mr. Combs understands he is not to travel to Los Angeles, where the plane had been located this week, and further that the plane is not to be brought to any district in which he is located until it is sold. Home detention with GPS monitoring and all other standard conditions of pretrial supervision. On March 13, 2024, counsel for Mr. Combs emailed the assigned assistant United States attorneys. In this introductory mail, counsel identified himself as counsel for Mr. Combs and stated that he wished to speak with the prosecutors and share information about Mr. Combs and the matters under investigation. After not hearing back from the assistant U.S. attorneys, counsel again emailed the prosecutors on March 18th. Counsel did not get a response to his second email either. On March 25th, 2024, search warrants were executed at Mr. Combs' places of residence in Miami and Los Angeles. In addition, he was removed from his airplane and searched. The searches of the residences were unusually public and particularly heavy-handed. No, they weren't. They were not particularly heavy-handed, in my opinion. The agents had assault rifles trained. Oh, okay, sorry. Minus the children. I'm sorry, I forgot about the children. The agents had assault rifles trained on the heads and the chests of his children, who were then handcuffed and brought before news cameras and a press helicopter. On the day of the searches, counsel called the prosecutors and they spoke for the first time. Counsel indicated that he would accept service of 2 grand jury subpoenas to Mr. Combs' businesses. Here's the thing. The assistant U.S. attorneys don't owe you a response to your emails about that subject. They responded to the ones they wanted to, but they did not owe you a response. Yeah, oh, it's cute that you said where he'd be, yay for you or whatever he had going on, but they don't owe you that. They'll respond when they owe you. Counsel took possession of Mr. Combs' passport on April 1st, 2024. I'm not going to reread about his passport again. They agreed to advise the government of all domestic travel. They advised the government of Mr. Combs' effort to sell his airplane. Voluntarily relocated to New York in advance of his arrest. So nobody cares. It says, since Mr. Combs has relocated to New York earlier this month, counsel has been looking for a 1-month rental for Mr. Combs in New York City. Despite counsel's persistence, it has been challenging to find a rental for many reasons, including because of the numerous events occurring in New York City in September. Example given the U.S. Open, Fashion Week, and the UN Summit, and some landlords' discomfort with having Mr. Combs as a tenant given the investigation. Yes, shout out to the landlords. Last night, counsel had scheduled a viewing of a potential apartment. However, because of Mr. Combs' arrest, counsel and Mr. Combs obviously were not able to view the rental. Yeah, So your rental is that cell. That jail cell is his rental. You ain't got to worry about it. Free 99. Kim said, bruh offered to sell his mama's house. Yeah. Yep. Sharon said, I wonder how did he treat his mother, sisters, and daughters. Let me see. Well, in this indictment, it does not reference murders, SC. So yeah, it is not straightforward to a murder in these indictments. Could there be something referenced about a conspiracy? But even then, the conspiracy is the they didn't reference that. I'm just gonna say they didn't reference that. Okay, Nanny of the Maroons, I see you. A beautiful place to live. Come visit sometime. I do want to do a Europe visit. So one day, speak it into existence. One day I will. Yes. Come on, Europe trip. Okay. So let's see here. It says, I want to see something else. I'm going to read this other paragraph I skipped. It says, once it became, counsel offered to continually share Mr. Combs' location with the government. Since arriving in New York on September 5th, Mr. Combs has been staying at the Park Hyatt, New York. Due to bookings made at the Park Hyatt prior to Mr. Combs' reservation after today, September 17th, 2024, he would no longer be able to stay at the Park Hyatt. They didn't want him either. Because I'm going to tell you right now, money talks. And they didn't want his money because he probably could have extended that stay, but they said, nah, we good. Don't try to give no extra money. Go ahead and check out. Accordingly, Mr. Combs had a reservation to stay at the Carlisle Hotel starting today. Don't worry about it. His hotel is that jail cell. Don't even worry about it. Counsel advised the government that it was in possession of the passports of members of Mr. Combs' family. Counsel's assistant to the government concerning the subpoenas. As stated above, counsel accepted service of 2 subpoenas directed at several of Combs' businesses in March of 2024. Separate counsel for the entities filed a motion to quash those subpoenas in April of 2024. In May of 2024, upon becoming sole counsel in connection with the criminal investigation of Mr. Combs, we advised the court that it would withdraw the motion to quash the grand jury subpoenas and instead that the parties would meet and confer with the government to minimize the number of requests on which the parties disagreed. Counsel agreed to begin gathering documents responsive to the subpoena. For the past several months, counsel for Mr. Combs and the assistant U.S. attorneys have had regular discussions about what documents we had, what we did not have, and in regard to the documents we did not have, where the government may be able to find such documents. We did this for 2 reasons. First, there was nothing in counsel's estimation that would constitute evidence of Mr. Combs being involved in any federal crime. Second, we wanted to be appropriately helpful to the government in its investigation. To that end, the Combs entities have produced over 144,000 pages of documents to the SDNY in compliance with the subpoena. Paying off the mortgage, so he paid off his mortgage. We submit this as a truly extraordinary measure that shows resoundingly that Mr. Combs is appropriately focused on defending this case on the merits in this court. Legal standard. Because Mr. Combs is presumed to be innocent, the Supreme Court has observed that liberty is the norm and detention prior to trial or without trial is the carefully limited exception. As the Supreme Court recognizes the function of bail is limited, the underlying goal is securing the presence of the defendant rather than the sum of bail. When deciding an issue of pretrial release, the Second Circuit has noted that the court should bear in mind that it is only a limited group of offenders who should be denied bail pending trial. And he, to me, falls in that limited group of offenders. Indeed, the Bail Reform Act requires that the court impose the least restrictive condition or combination of conditions that will reasonably assure the appearance of the person as required and the safety of the community. Exactly. He needs to stay behind bars. He is going to be dispatching his people to continue to intimidate and tamper, in my opinion, with witnesses and victims. That they did it right. This is the time that you hold the person. This is one of those times. While there is a presumption of detention in sex trafficking cases, this presumption is rebuttable. The presumption imposes on the defendant a burden of production, while the burden of persuasion remains with the government. Although this burden is not heavy, the defendant must introduce some evidence contrary to the presumed fact. A defendant can satisfy this burden by coming forward with evidence that he does not pose a danger to the community or a risk of flight. Literally, the judge has evidence otherwise. Literally, he did it. Arrest, lawsuit out. Let me start harassing more witnesses and victims. Yeah, shout out to the landlords messing up people's hotel rooms, regardless of whether he paid the damages or not. Sicko. I think the feds has an informant that told them Diddy was planning to run. That's why they arrested him earlier than scheduled announced. I agree, Creole girl. I agree. Okay, let's see. The benchmark case defining this burden shift, the court explained, since the presumption is but one factor among many, its continued consideration by the magistrate does not impose a burden of persuasion upon the defendant. And since Congress seeks only consideration of the general drug offender flight problem, the magistrate or judge may still conclude that what is true in general is not true in the particular case before him. He is free to do so and to release the defendant as long as the defendant has presented some evidence and the magistrate or some judge has evaluated all of the evidence with Congress's view of the general problem in mind. Yeah. Acknowledging that sex trafficking has a rebuttable presumption of detention, Mr. Combs can rebut such a presumption with evidence that he does not pose a danger to the community and is not a flight risk. An analysis of the Section 3142G factors weigh in favor of releasing Mr. Combs on these conditions. The nature and circumstances of the offense. Mr. Combs is charged with a 3-count indictment. The first count charges Mr. Combs with a racketeering conspiracy. Count 1 alleges that Mr. Combs relied on the employees, resources, and influence of the multifaceted business empire that he led and controlled, creating a criminal enterprise whose members and associates engaged in and attempted to engage in, among other crimes, sex trafficking, forced labor, kidnapping, arson, bribery, and obstruction of justice, and that the conspiracy lasted from at least in or about 2008 through on or about the filing of this indictment. I'm going to go down. I'm trying to see their argument. They're quoting everything, so I'm trying to see. They're talking about the second count, which we read earlier, talking about the third count. So I want to see what they say. Okay, so it says defendant's history and characteristics. Mr. Combs' history and characteristics are best demonstrated by the way he has responded to this investigation from the very inception to his most recent decision to travel to New York when his lawyers told him that the case could soon be starting. He has never run from a challenge, and he will not run from this one. Tomatoes. Instead, he takes these challenges head on. He moves toward them confidently and with the assurance that right is on his side. These are not merely the words of his lawyer, rather the actions of Mr. Combs over the last several months conclusively prove this. Aside from his actions since the inception of the investigation, Mr. Combs' character is shown through his demonstrated contributions to society in several important areas. First, he has given generously over his entire life to charitable causes. Many predators give to charitable causes. He is a deviant, Mary. Hey, Mary. Hey, Miss Sweet Tooth J. Hello, new subscriber. Thank you for subscribing. I think they scooped him up a day early so his lawyers couldn't argue he wasn't a flight risk because he handed himself in. I agree. I agree with you. Exactly. They were like, no, babe. No, you got to stay. But yes, they definitely were like, oh, look, he's here early. He's not going to go anywhere. No, we're done here. Okay. To name only a few examples, since founding Bad Boy Entertainment in '93, Mr. Combs has actively supported and donated millions to after-school programs and organizations like the Boys and Girls Clubs of America. His commitment stems from the positive influence such programs had on his own childhood, inspiring him to give back to similar initiatives. He has also supported organizations including the National Foundation for Teaching Entrepreneurship, further emphasizing his dedication to creating opportunities for young entrepreneurs. A cornerstone of his philanthropy is education, and he fulfilled a lifelong dream when he, with a partner, opened Capital Prep Harlem Capital Charter School in 2016 to provide high-quality education to inner-city youth in New York City. The success of this initiative led to the launch of Capital Prep Bronx Charter School in 2020, with Combs donating $1 million to support its development. These schools are part of his broader commitment to education, which includes significant contributions to historically Black colleges and universities, such as $2 million to Howard University and $1 million to Jackson State University in 2023. Mr. Combs has also been proactive in health and disaster relief efforts, having raised over $2 million for New York City public schools and hosting a virtual dance-a-thon that raised more than $4 million to provide personal protective equipment to health workers on the front line for C-19. Particularly important in an election year is Mr. Combs' contribution to mobilizing young voters with the Vote or Die slogan through Citizen Change, which he founded to significantly increase political awareness and youth voter turnout. That's great. It's great that the monster did do something good, and I hope the people that are running those organizations, boots on ground, continue to make those things great. Does not take away from the things this man did. Second, few people have done more to advance the cause of Black people in the music. Boy, now stop it. Now stop it. No, they didn't. With him holding people's masters and suppressing people's careers, I know they did not put this paragraph in here. If nothing else, if nobody ever heard of any of the sexual stuff, if nobody ever heard of any of the violence, everybody knows how he did Total, Danity Kane, Day 26, 112, you name it. Mary J. Blige, I think he did something to her. You name it, he did it. Now, I know they didn't have the audacity to put this in here about helping. Boy, I'm still going to read it for the record. I'm reading it, but no. Second, few people have done more to advance the cause of Black people in the music, entertainment, and fashion industries than has Sean Combs. While he has always been controversial, he has always also championed minorities and underrepresented communities. As chairman of Combs Global, Mr. Combs has used his platform to create the Excellence Program, an internship initiative with Endeavor in July 2021, a major initiative designed to provide development opportunities for aspiring execs in entertainment, marketing, music, and fashion from underrepresented communities. Mr. Combs' philanthropic work has earned him numerous accolades throughout his career, including the Triumph Award from the National Action Network in 2016, the Superhero Award from Room to Read in 2017, the Child of America Award from the Carver Foundation in 2018, and in 2023, the Icon Award from the Apollo. Through his multifaceted career, Mr. Combs has not only created thousands of jobs, including valuable internships for young professionals, but has also supported minority and women-owned businesses, leveraging them as key suppliers and vendors for his enterprises. Counsel will be prepared to address the factors of dangerousness to the community and weight of the evidence in court at the 2:30 p.m. initial appearance. Don't care. Again, hope those foundations are ran by better people right now and they keep it going, but we do not care. He needs to go. So that overrides whatever good deeds he has done, so we don't care. Whatever. Right, Bonnie? Hey, Mary White. He gave from his excess, not from his need. He doesn't even care about those folks. He doesn't, Indigo Girl. In fact, basically, he exploits the people that are the underrepresented, the underprotected. That's his exploitation grounds right there. Yet his private jet was at the New Jersey airport. BS. If he wasn't going to try and get the hell out of the U.S. Right. I think first thing I thought about was Russell Simmons, Mary. I sure did think that. Yes, sure did. The proposed bail package addresses any issues with flight and danger to the community. In light of the proposed conditions, the actions Mr. Combs had already taken regarding the investigation and Mr. Combs' lifetime commitment to live up to his obligations concerning every challenge he has ever faced, he should be released to fight this case in court and prove his innocence. Sean Combs has never evaded, avoided, eluded, or run from a challenge in his life. He will not start now. As he has handled every hardship, he will meet this case head on. He will work hard to defend himself, and he will prevail. Recognizing that a bail hearing is not the time to defend the merits of a criminal case, it is relevant to bail that the defendant has made a clear commitment to defend an eminently defensible case. This is such a case. Finally, several courts in this district have recognized that the conditions at Metropolitan Detention Center in Brooklyn are not fit for pretrial detention. Just earlier this summer, an inmate was murdered. At least 4 inmates have died by suicide there in the past 3 years. Numerous courts in this district have raised concerns with the horrific conditions of detention there. Let me see. See the conditions at MDC as dreadful and longstanding, and noting that the issues with food contamination and hazardous physical conditions were an ongoing tragedy. For the overall inmates that are in there, because I don't know all the reasons. In anything, I feel like they should still clean that up, like still do something about that. but he still needs to be held without bond also. It says it was dirty, infested with drugs, and plagued by violence, describing overcrowding, staffing issues, and lockdowns, describing MDC conditions as disgusting and inhuman as anything I've heard about any Colombian prison, but more so because we're supposed to be better than that. Let's see. The court noted it was worried about MDC's conditions as one of the reasons for sentencing the defendant to a non-custodial sentence, sentencing a defendant to 9 months in prison, but ordering that if BOP designated the defendant to the MDC, the court would vacate the sentence and resentence to home incarceration. In these other cases, State versus Forbes and United States versus Colucci, they're referencing those cases. Conclusion: for the reasons set forth above, we move this court to release Combs under the conditions set forth above. Thank you for your consideration. Okay. No. Basically, no. And then the court did set a bond hearing, which I already know the outcome of it, for September 18th, 2024. It was rescheduled to 3:30 p.m. And then, what is this? All right, here's an order. So we're going to look at the court's order. All right. This is from Judge Tarnowski. This order is entered pursuant to Federal Rule of Criminal Procedure 5F and the Due Process Protections Act to confirm the government's disclosure obligations under Brady versus Maryland and its progeny, and to summarize the possible consequences of violating those obligations. The government must disclose to the defense all information favorable to an accused that is material either to guilt or to punishment and that is known to the government. This obligation applies regardless of whether the defendant requests this information or whether the information would itself constitute admissible evidence. The government shall disclose such information to the defense promptly after its existence becomes known to the government so that the defense may make effective use of the information in the preparation of its case. And y'all, if you're following YSL, of course, you have definitely heard Brady be referenced a lot during there because the prosecution between Love, Hilton, Atkins, the other ones that we've seen now, question witnesses, they had access to Brady material a few times and they did not immediately turn it over to the defense. And of course, that case came about because the prosecution has to provide possible exculpatory information to the defense. As part of these obligations, the government must disclose any information that can be used to impeach the trial testimony of a government witness within the meaning of Giglio versus United States and its progeny. Such information must be disclosed sufficiently in advance of trial in order for the defendant to make effective use of it at trial or at such other time as the court may order. The foregoing obligations are continuing ones and apply to materials that become known to the government in the future. These obligations also apply to information that is otherwise subject to disclosure, regardless of whether the government believes it. In the event the government believes that a disclosure under this order would compromise witness safety, victim rights, national security, a sensitive law enforcement technique, or any other substantial government interest, it may apply to the court for modification of its obligations, which may include in-camera review or withholding or subjecting to a protective order, all or part of the information otherwise subject to disclosure. For purposes of this order, the government has an affirmative obligation to seek all information subject to disclosure under this order from all current or former federal, state, and local prosecutors, law enforcement officers, and other officers who have participated in the prosecution or investigation that led to the prosecution of the offense or offenses with which the defendant is charged. If the government fails to comply with this order, the court, in addition to ordering production of the information, may specify the terms and conditions of such production, grant a continuance, impose evidentiary sanctions, impose contempt or other sanctions on any lawyers responsible for violations of the government's disclosure obligations, or refer to the matter to the disciplinary authorities, dismiss charges before trial, or vacate a conviction after trial or guilty plea, or enter any other order that is just under the circumstances. Bonnie said meet it head on then, but without bail or bond. So basically he can handle it, then do so behind bars until trial. I hear you, Bonnie. Okay, last document I have is the letter from the Department of Justice to Judge Carter. Okay. All right. It says United States versus, this is regarding United States versus Sean Combs. And it says, Dear Judge Carter, the government respectfully submits this letter in advance of the bail appeal by defendant Sean Combs. For the reasons set forth below and in the government's September 17th, 2024 detention letter and argument before the magistrate court, the defendant presents a danger to victims and others, both through physical violence and through obstructive conduct and a risk of flight. He must be detained. Additional background. The relevant factual background is set forth in detail in the September 17th letter and incorporated by reference herein. The defendant was arrested on September 16th, 2024, and arraigned on September 17th, 2024, before the Honorable Robin F. Tarnowski. Following arraignment, the government sought the defendant's detention on 3 grounds: dangerousness, obstruction, and risk of flight. Pretrial services similarly recommended detention for the defendant. After an extended bail argument, the court found that the defendant had failed to rebut the presumption of detention in this case. Judge Tarnowski noted that the crime of sex trafficking is a crime that happens behind closed doors and expressed concern that such conduct could not be monitored by pretrial services. The court further found that detention was warranted based on the defendant's history and characteristics. There are also indications in your history and characteristics that I think are a reason why the presumption in favor of detention has not been rebutted. Prior substance abuse and the fact that the alleged violence seems to occur hand in hand with times when you are not necessarily in control of your actions because of that substance abuse. Your lawyer asked me to trust you and to trust him, and I don't know that I think you can trust yourself, and I don't believe that counsel has the ability to control you given the very significant concerns I have, particularly because of substance abuse and what seems like anger issues. In addition, the court noted that the weight of the evidence is significant given that the government has proffered that there are multiple witnesses who are saying that they have witnessed significant serious violence. Finally, the court concluded that the danger posed by the defendant was quite serious due to the defendant's access to weapons, use of violence, and the coercion of witnesses. This court should reach the same conclusions. Judge Tarnowski's findings are well supported by the record before the court today and demonstrate why the presumption of detention is not rebutted in this case. Moreover, defense counsel's most recent letter fails to seriously contend with the findings most glaringly related to the defendant's unpredictable dangerousness and inability to be monitored or controlled. The defendant poses a significant and ongoing danger. Despite public statements by counsel minimizing the defendant's conduct, both to Judge Tarnowski and the media, the defendant has committed incredibly serious crimes. As alleged in counts 1 and 2 of the indictment, among other crimes, the defendant used violence, threats of violence, and coercion to cause women to engage in commercial sex acts. In other words, the defendant committed sex trafficking, a crime so serious that Congress has determined that there is presumptively no condition or combination of conditions that will reasonably assure the safety of the community and the defendant's appearance in court. The defendant's crimes have spanned over a decade and continued through this year, putting others around him, including both victims and witnesses, at risk. The nature of the offenses and the defendant's history and characteristics demonstrate the danger he poses and weigh heavily in favor of detention. The defendant's repeated acts of domestic violence, which are recurrent and, as noted by Judge Tarnowski, often occur behind closed doors, are not disconnected to the offense conduct. They are an element of it. The physical force and coercion the defendant repeatedly used during and apart from the freak-offs caused victims to engage in the sexual activity. That is sex trafficking. These acts of physical force of violence are corroborated not only through victim testimony, but also through, among other things, victim communications with the defendant spanning years of the charged time period. Witness testimony, including witnesses who were present during and after freak-offs, video footage, photographs capturing victim injuries, and law enforcement records, among other things. The same is true of the defendant's coercion. The communications between the defendant and multiple victims, which include communications sent as recently as this year, capture victim resistance to engaging in freak-offs, even in light of the defendant's abusive tactics. The defendant's years-long use of force and coercion speaks directly to dangerousness. To be clear, despite the indictment naming one victim in count two, this case is not about just one victim. The government's evidence to date, including the defendant's own communications, demonstrates that the defendant has used force and coercion against multiple victims. In addition to these women, the defendant has assaulted a host of other individuals, including his employees and witnesses to his violence. For example, the defendant directed his rage toward his employees and those close to victim one who had seen him physically abuse victim one, including by throwing these witnesses against walls and onto the ground, choking them, and throwing objects at them, among other things, particularly when they attempted to protect victim one. In doing so, the defendant has demonstrated that he is not only a danger to victims and witnesses, but is also obstructive and willing to engage whatever is necessary, including physical violence, to instill fear in witnesses to keep them silent. All of this violence against victims, witnesses, and others factor into the analysis of the defendant's dangerousness. The defendant has consistently obstructed justice. Equally, as outlined in the government's September 17th letter, the defendant poses a significant risk of obstruction. The defendant's argument that his recent contacts with witnesses to the charged conduct should not be considered obstruction because he was unaware of the government's investigation simply cannot be credited. The defendant has been aware of the government's investigation of this case since at least in or about January 2024. And even earlier, directly following the filing of a civil lawsuit in November 2023, the defendant was aware of the potential for criminal charges. Nevertheless, since that time, the defendant has continued his long-standing pattern of engaging in obstructive conduct. Defense counsel acknowledges that the defendant has contacted witnesses in this investigation, apparently with counsel's blessing, but claims that the defense has studiously avoided interviewing grand jury witnesses. The fact is, the defendant has personally and repeatedly contacted multiple witnesses, including at least one he himself knew was a grand jury witness. The defendant contacted these witnesses, including at least one whom he had not been in contact with for years after they were served and leading up to the date they were required to appear before the grand jury. The defendant's behavior illustrates Judge Tarnofsky's point that counsel cannot control their client. Moreover, contrary to counsel's protestations to the contrary, there is ample evidence from which to infer that the defendant's contacts are not innocuous. Indeed, the government has multiple examples of the content of such communications between the defendant and or his intermediaries and victims and witnesses. These communications include feeding victims and witnesses false narratives of events that they observed and or personally experienced. And they include communications were even made in the aftermath of the November 2023 civil lawsuit, during which the defendant was clearly concerned about the possibility of potential law enforcement scrutiny. And as during several calls, the defendant expressed his concern that his communications may be monitored. Example, I can't really talk on this phone. You feel me? I'm not even supposed to be talking on the phone. I can't be on these phones and it's like that. You feel me? I can't even talk on the phone. Like, please don't send no text or do nothing. People misread NS. And it has them stuttering on some parts of it. Finally, it bears noting that within the first 24 hours of this case's unsealing, there are already new concerns about witness interference as well as interference with a fair trial based on the defendant and his counsel's attempts to publicly discredit one of the victims. As Judge Tarnofsky noted in her ruling, one of the pertinent concerns here is the power imbalance in the case. The defendant, as alleged in the indictment and publicly known, is a man of immense power and influence. Consequently, his ability to coerce victims and to influence witnesses is outsized. Just yesterday, during the Bell argument and a subsequent appearance on CNN, defense counsel impugned the allegations made by a statutory victim, challenging the motivation and timing of her claims. In addition to being factually inaccurate, this sort of attack comes close the limits set forth in L Criminal R 23.1. It also can be expected to intimidate other witnesses who may feel tremendous pressure not to go up against the defendant. The government therefore requests that the court caution the defendant and counsel not to violate L Crim R 23.1, including by publicly challenging the credibility of prospective witnesses or by publicizing information counsel knows to be likely inadmissible at trial. Moreover, the government submits that this is yet another example of the defendant's ability to obstruct these proceedings, even through the media. It says United States versus Bankman-Fried, remanding defendant who disseminated materials to the media in an effort to discredit and intimidate a trial witness. The defendant poses a risk of flight. Hey, Peaches and Cream. Both at argument yesterday and in the press, the defendant has emphasized his supposed cooperation with the government, including his willingness to surrender. The court should take that argument for what it truly is: attorney-crafted theater designed to convince this court that the defendant can be trusted and is not a flight risk. Make no mistake, the defendant's recent behavior shows that he cannot be trusted or controlled, particularly now that he is facing serious charges that carry significant penalties. As Judge Tarnofsky observed, your lawyer asked me to trust you and to trust him, and I don't know that I think you can trust yourself, and I don't believe that counsel has the ability to control you. Indeed, since at least in or about January 2024, when the defendant was unquestionably aware of the criminal investigation, the evidence shows that he has engaged in multiple freak-offs, some involving the interstate transportation of individuals to participate, has continued to use narcotics, and has contacted multiple witnesses. Some of this conduct has even taken place since the defendant arrived in New York City, allegedly to sit it out and wait to be arrested. The defendant's conduct is demonstrably not cooperative and indeed highlights his inability to abide by the law or counsel's directives. The defendant's detention is consistent with case law. The defendant's attempts to distinguish recent sex trafficking cases in which defendants were detained pending trial are unavailing. Hold on one second, y'all. Peaches and Cream, I had to wait till you came here so I could change you. All right, there we go. Okay. A review of the case law confirms that pretrial detention in this case is consistent with the rulings in other similar cases, particularly cases in which obstruction was a concern. For instance, in Epstein, there goes Epstein, Judge Berman ordered the defendant detained on dangerousness, obstruction, and risk of flight grounds, despite the fact that the charged conduct, as well as the bulk of the obstructive conduct, took place approximately 1 decade prior. See United States versus Epstein. Specifically, Judge Berman found that the defendant's pattern of sexual misconduct, as well as his long history of attempting to intimidate, harass, and buy off potential victims as witnesses, made him a danger to the community. Similarly, in United States versus Kelly, the defendant was detained on dangerousness, obstruction, and risk of flight grounds. There, the court found the defendant's dangerousness based on the seriousness of the charges, which dated back more than a decade and included sexual and physical abuse of minors and adults alike, such as hitting, slapping, punching, and spanking. The court also found that the defendant's obstructive conduct and witness tampering, which related to the matters charged, were grounds for detention. Judge Garafis denied the defendant bail in United States versus Rainier, noting that the defendant posed a danger to the community due to the nature and circumstances of the charged sex trafficking conduct, which did not, at the time of the bail determination, include allegations involving minors, and crediting the government's representations that, I'm going to say, NXIVM critics and defectors faced harassment. See also United States versus Ray, detaining defendant in one victim sex trafficking case after government argued, among other things, that the defendant intimidated and threatened witnesses. Far from supporting the defendant's position, these cases instead stand for the proposition that sex trafficking defendants, regardless of the age of their victims, are routinely detained pre-trial, especially when they have engaged in repeated obstructive conduct. The new proposed bail conditions fail to adequately address the risk of danger or obstruction. Finally, the new conditions proposed by the defendant fail to adequately protect the community against his dangerousness and ability to interfere with witnesses. Indeed, these conditions do not speak at all to the defendant's risk of obstruction. Further, considering that the defendant's proposed conditions still contemplate him having staff and visitors, they cannot adequately protect against dangerousness. The government's evidence, as described above and in the indictment, includes numerous instances of assaults on his employees, as well as the involvement of his high-ranking supervisors, personal assistants, security, and household staff, all of whom frequently work in his homes, in offense conduct. Accordingly, the defendant has failed to rebut the presumption in favor of detention. Conclusion: for the reasons set forth above, there are no conditions of bail or combination of conditions that will reasonably assure the defendant's appearance and compliance or the safety of the community. Accordingly, the defendant's application for bail should be denied. Submitted by Damian Williams, United States Attorney. All right. All right. That is, and then we know it, of course, again, it was denied that second time. So, yes, that's where it should be. We have YSL this weekend, so we will be recapping some of the trial days that have happened. So hopefully y'all join me, new subscribers. Hope y'all enjoy the recaps that we do. Also, I do have a second channel trending at some point, and that's where I'm going to have my trend talk with my first guest tonight at 7 p.m. Eastern Standard Time if you'd like to join. And you will get to ask some questions of my guests. So I hope y'all enjoy it. She's kicking it off for me, and I'm really excited. All right, y'all. But I will see y'all soon because I have a lot of note taking to do this weekend. All right. Talk to y'all later. Bye.